Good afternoon, everybody, or morning, depending on where you are and when you're watching this. Thank you for joining us today. Happy to do another presentation for what it should be a pretty popular topic, something we get contacted a lot about. A lot of material to cover today. Starting a medical practice. This can apply to a physician practice. It can apply to other types of medical practice as well, home health care, chiropractic. Some of it will apply. Some of the details will be a little bit different, but hopefully this will provide you with a roadmap if you're dealing with clients. I know we have some attorneys, some accountants, maybe other professional advisors on here. There's not going to be a high level of detail because of the amount of content that we have, but some of these topics I'm going to discuss today, I've actually broken these out into seminars in and of themselves where we go into a lot more detail, credentialing and business organization and so forth. And I do intend to do that in the future. Here's an overview agenda on the screen of the topics that we'll discuss today. And again, this is probably enough material that we could talk at a relatively in-depth level for a few hours, maybe 4 hours or so. I'm going to cover this in an hour. If you have any questions throughout the seminar today or afterwards, feel free to either drop them in the chat box or contact me afterwards, and we can discuss it in further detail. This material has been written out in further detail in a chapter that I'm doing for a book, an advisory book on this type of content. And of course, that has a lot more detail to it. And if you're interested in that, please let me know. We'll jump in here and start with our introduction, which basically, what I want people to understand from this is that there are a number of different components, legal components and advisory components that folks need to be aware of whenever you're starting any type of business, especially a regulated business like a healthcare business. You have state laws, federal government laws. You have governing documents for your entity, contracts, relationships with employees, with partners, with vendors, with patients, insurance companies, third-party payers. And we're going to try and talk about a little bit of each of these components throughout the seminar. And I'm going to also, as you'll see when I hit on different slides, there's certain practice pointers I'm going to toss out for you to really call your attention to things that I see, mistakes that I see that are made, or misconceptions that they come up most frequently in my practice. Hopefully those will be helpful to you as well. First thing we'll talk about is organizing the entity. You're going to start a business. You don't want to do it necessarily in your own name, unless, of course, you're restricted by that in a particular state where you're operating. A consideration at the bottom of the slide you'll see here is corporate practice of medicine doctrine. That essentially discusses the law of the state where you practice as to who can own a medical practice. In my home state of Florida, corporations, the reason it's called the corporate practice of medicine doctrine is the idea of whether or not corporations can own a practice or they must be owned by individuals. And it extends further to this philosophy of, can corporations own a medical practice? Can corporations practice medicine? Well, obviously, corporations themselves don't practice medicine any more than corporations cut grass or sell cars or sell gas. It's all done through the people who operate within the corporation. But you need to understand from the start, if you are advising owners starting a business, again, it'll depend on your particular state and the particular practice, whether or not a business operating in the healthcare space can be owned by only individuals who are licensed in that practice, if it can be owned only by entities owned by individuals licensed in that practice, or if it can be owned by entities that are owned by individuals who are not licensed. In Florida, we can have private equity funds and corporations who are not licensed practitioners own a medical practice, provided they comply with the Florida Healthcare Clinic Act, which would require that business to have a healthcare professional, a doctor, or a physician as the medical director, and also comply with other requirements. That's unique to the medical practice in Florida. So if you have a dental practice, for instance, or an optometry practice, the rules are not the same. Dental practice can only be owned by licensed dentists in Florida. When you go to other states, you'll find that some states require physician practices be owned only by physicians or entities owned by physicians. Other considerations when you're forming the practice entity, state of formation, generally I like the state, would generally recommend that the state you are forming in be the state where you form your entity. Just makes it easier from perspective of local compliance, not having to file a registration, for instance, trying to register a Delaware entity and then bring that Delaware entity to Florida and having to do a local filing here in Florida and explain why the entity is an out-of-state entity. I think you avoid some of those early issues by creating your entity in the state where you practice. There are some exceptions to that, of course, as companies grow larger. They may be under one umbrella entity, which is formed in a different state, and they practice across various jurisdictions. Licensing varies from state to state. The name regulations vary from state to state. These are all the things you need to be aware of when you're setting up the company from the beginning, and you're essentially picking what type of entity you're going to be, who's going to be the owners, or if it's going to be an individual or if it's going to be several individuals, and then what's the ownership structure going to look like? What's the entity structure going to look like? I want to draw your attention to the governing documents of the entity. Governing documents refer to things such as bylaws, shareholder agreements that you'll see in a corporation, or an LLC agreement, or operating agreement, or partnership agreement that you'll see in a limited liability company or in a partnership. Sometimes these aren't required. You can form an LLC in various entities, and generally an operating agreement is not required under the law. But the operating agreement is a good foundation. It provides the baseline for what the rules, the governing document, the constitution of the business, especially if you're going to have more than one owner, more than one member of the company. It's a good idea to have an operating agreement that spells out what are the rights and duties of the members and of the managers. Is it member managed or manager managed? How do you call meetings? What's the requirement for meetings? How is voting done? Who makes the day-to-day decisions on the business? What happens if there's a dispute among the individual owners of the business? And I like to use this analogy, and anybody who's heard me talk about this before, this will sound familiar. I like to say that contracts, including an operating agreement or bylaws, which is essentially a contract between the company and its individual owners, members, or directors. Contracts are like fences. If you think of, if you live in a neighborhood and you like your neighborhood, you have good neighbors, you still may put up fences between yards. It just lets everybody know where the boundaries are. It's not a be-all, end-all to create privacy. If somebody wants to hop over your fence or dig under your fence, burn it down, chop it down, or figure out some other way around it. If you live near some dirtbag, or if somebody wants to break into your house or into your yard, there's ways to do that. But as a general rule, if you have a fence up and you have a pretty good neighbor, neighbors tend to honor that as the boundary, and not only as a physical boundary, but as a boundary for privacy and courtesy, noise, and so forth. Governing documents, contracts, very much the same. If you're doing business with, for lack of a better word, if you're doing business with somebody dishonest, or if you're doing business with a scumbag, they're going to find a way to get around a lot of the provisions in a contract, or they just simply won't honor it. And hopefully you have a good document that provides for remedies. But the first step, I like to say, when you're starting a business, is consider the people that you're getting in business with. And that's the start, and then build off of that foundation. Do business with good people, then try to find good advisors, use good documents, and follow good business practices from day one. I talked already a little bit. I think maybe I went a little bit backwards, but here's some further notes on the corporate practice of medicine doctrine. And I want to call out this slide bullet here that talks about the medical director. In Florida, a physician can be a medical director for more than one practice, and it's often a nice side gig for licensed physicians. But I want you to be aware that if you're in that role, or if you're advising somebody in that role, it comes with a lot of responsibilities. It also comes with a lot of potential liabilities. If the medical practice is licensed as a healthcare clinic and has a medical director who has signed on to be that clinic's director, and the clinic is not doing something right, if it's engaging in improper billing, if it's not securing medical records properly, or if it's doing something else improper, potentially the medical director individually can be liable for those faults. So you want to be careful. And again, if you're in the position of potentially being a medical director or advising a medical director, please be aware that you have potential liability that comes with the gig. I'm often asked when starting an entity about the differences. What's better, an LLC? Actually, the common question we get is what's better between an LLC and an S corp? And the answer to that is it's not really a proper question, or maybe it's almost like a trick question, or a question that comes from a lack of understanding. S corp is a tax designation. I'm not a tax professional. I refer folks to work with tax professionals. We do have some tax lawyers in the office. But I can tell you that you can be a corporation in Inc., a corporation under state law, and that's a legal designation. You can be a corporation, or you can be a limited liability company, an LLC, or a different type of entity. A corporation or an LLC, generally, so provided it complies with the tax rules for S corporations, can make an S corp designation. So it doesn't matter. For those of you who have an LLC and you've been told by somebody, and it's some type of advisor, that you should switch to a corporation so that you can be an S corp, you should reconsider your relationship with that advisor. Hopefully people aren't telling people that at this point. I've harped on this before. You make your legal designation, and then you make your tax designation, and the two are mostly independent. You can be an LLC and then opt to be taxed as an S corp and file your 1120S and so forth. The reason I like LLCs over corporations is they essentially offer the same benefits as far as veil protection from liabilities. So if you have, let's say, a loan with the company, or there's a slip and fall on a property that's owned by a corporation, an employee goes rogue in that entity and creates some type of liability, the corporate veil will protect your individual assets. Now, there's an exception to that when you're providing professional services yourself, but generally the corporate veil provides a lot of liability protection, and that protection from inside the entity is the same for LLCs and for corporations. Where it differs significantly is if you have individual liability. Let's say you have a loan that you help guarantee, or a business investment, something else personal, and you have a potential creditor who's coming after your assets and looking at the entities that you own. If you own shares of corporate stock, those are generally subject to foreclosure and attachment by creditors, where LLC interests are much more limited. So that's why I like LLCs better. In addition, the corporate formalities in LLCs are much lower than they are with corporations. So if you're trying to pierce the corporate veil with corporations, we'll typically ask for things like meeting minutes, corporate resolutions, bylaws, and so forth. And if you don't have those, it can be trouble. If you have the same situation with an LLC, an operating agreement is option. It's helpful to have it, but it's not required to have annual meetings and so forth. All right, I'm going to move probably even a little bit faster just to make sure we cover the material, but that's a big issue for people when they start off. A lot of questions I get there on entity types and background. Insurance coverage, what I tell folks who come to me, I'm not an insurance professional, find a good insurance advisor. I do know some folks who work in commercial insurance and professional liability insurance and can provide you good advice. I'm happy to refer those folks out because I have confidence in their abilities. On the screen here is a list, and it's probably not an exclusive list, but it's pretty detailed as to the types of insurance that you will encounter in your practice. Everything from general liability, cyber, key man is a unique type of policy that you have typically for where a business is owned, a practice is owned by more than one person. And the idea is it's life insurance on the individual. So if one person passes away, it covers the company, it pays the company so the company can buy the interest from a spouse or from the family. Professional liability insurance, we'll talk about on the next screen. But again, each one of these is a different type of insurance that may or may not apply to your particular business. Consult with a professional in this area, or I'm happy to talk about it generally and try and get you pointed in the right direction. Some confusion arises when we talk about professional liability insurance and the different types of insurance and how they work, how they're different and how they work together. The two main types of liability policies are claims-made policies and occurrence-based policies. And well, typically, if you're signing, for instance, an employment agreement with a practice, you'll see language, or if you're coming in as a partner or a shareholder in a practice, you'll see language talking about what the practice offers when you come in, whether that's a claims-made policy or an occurrence-based policy. Generally, the claims made is usually what's offered because it's generally the cheapest from the start. That covers claims that are made, while the policy regarding incidents that occurred when the policy was in effect, and the claim has to be made when the policy was in effect. So if you're covered by a policy and there's a potential liability issue that happens today, and next month you go somewhere else or you go to a different insurance company, you're no longer covered by that policy, a claims made policy is not going to cover you likely. Sometimes there's a short tail or an endorsement, but generally, let's say if it's a year later, the claims made policy is not going to cover you. An occurrence-based policy will cover you. Now, the occurrence-based policy is generally a better policy because of that better coverage, but it's going to cost you more money. So employers typically don't use the occurrence-based coverage. But there's no hard and fast rule to that. Oftentimes, if cost is a concern from the beginning, new businesses, startups like we're talking about today, tend to go with the claims-made coverage, and that will grow over time because as the years go by, your potential exposure period increases. Tail and nose coverage, the way they work is you'll see oftentimes tail coverage. If you leave if you're covered under one policy and you go somewhere else, this applies a lot for moving employees, but it can have other. If you go to start your own practice, if you're an individual working for someone else, you start your own practice and you say, okay, I'm going to get claims made coverage from the start. I came from a place where I had claims made coverage. And what if there's a liability issue, I want to make sure I'm covered. Then you get tail coverage. That tail coverage fills that gap. It covers you for the things that happened under the old policy. And sometimes that'll be required in certain circumstances to get new policies, but that's the interplay. Tail coverage follows claims made coverage. Nose coverage is sort of the opposite of that. Nose coverage, when you're purchasing a new policy, that nose coverage covers things that happen before the start of the policy. There's a lot of factors depending on the type of practice, where you are, if you've had prior liability incidents. There may be certain regulatory requirements, insurance company requirements for having these different types of coverages, but this gives you a good overview so you have background and being able to at least identify the issues that you'll have to deal with when you start getting into the insurance aspect of your new practice. This is a point that I wanted to, and I've made this point a couple times throughout the seminar today, that oftentimes people will see terms in some agreements and they'll think that that's a set term. Let's say you're coming into a practice and you're coming in as a new physician, and maybe you're going to be potentially a shareholder in a year or two, or you're just coming in as a physician employee. A little bit different topic than today, but there's a lot of overlap there. Or you're hiring a new physician into your practice. Who pays for tail coverage is a often highly negotiated provision, and it's used with other things such as compensation and other types of benefits and coverage. So just be aware that if you see some language that is in an agreement already, don't assume that that's hard and fast. You can often negotiate that. Next topic of contracting. If you take a look at this list, these are all different types of agreements, and it's, again, not a comprehensive list necessarily, but these are the most common types of agreements that you're likely to see after you start your practice or as you're starting your practice. This is beyond the governing documents. You're up and running. You're operating a new medical practice. You may have physician employment agreements, or you may have physicians or other professionals who are employed as independent contractors. I have small business clients where maybe there's one primary practitioner who started the practice and wants to bring somebody else in, but doesn't have the ability to bring that person in full time. They may bring them in as a part-time employee, or they may bring somebody else in who's working for another practice and they want some flexibility and they want to bring them in as an independent contractor. If you start poking around on the internet or you start asking different professionals, what's the difference between an employee and an independent contractor, you're likely to get a lot of different answers. The big takeaway I want people to understand in that regard is that there are different factors for what the IRS looks at from a tax perspective, and then different factors for what companies and what courts look at from a liability perspective when it comes to maybe workers' comp coverage, or when it just comes to the relationship with regard to whether somebody's an employee or independent contractor. We saw a big argument, different issue, but we saw this issue argued, a lot of the issues that were argued as far as the wage factor in the Uber cases that were in California, when the drivers who were treated as independent contractors were claiming they were entitled to wages and so forth as employees. That just gives you an idea that this is an area where there's a lot of gray area. Other types of agreements I mentioned earlier, medical director agreements. These will typically be between a clinic and a physician practitioner who takes on some level of responsibility in return for compensation for being the medical director for the clinic. This may be somebody who is also employed actively as a physician for the clinic, or it may be somebody who just serves the medical director role as really just on call as a backup for a supporting or as support for other professionals. Could also be, for instance, for professionals who are physician assistants who are working under protocols with physicians where they have a practice and they have a physician who's maybe the medical director. Advanced nurse practitioners may operate under a similar arrangement where they have their own practice, but they still have a medical director. A lot of different contexts where you can have a medical director agreement. Non-physician practitioners, as I mentioned, PAs, nurse practitioners, nurses, and so forth. Shareholder partnership agreement I referenced earlier. Want to just point out, and I'll hit this again in a few slides later, that there are specific elements and requirements to be a group practice. Being a group practice creates some advantages and flexibility, but also some restrictions with respect to providing ancillary services under Stark and kickback laws. If you're entering into a group practice, or if you're creating a practice you intend to be a group practice, you want to ensure that if that's your goal to provide these additional services, or if it's for a Stark or a kickback exception, that you meet the requirements for what's defined or described as a group practice. Confidentiality and NDAs, these are very common. If you're entering into any type of business relationship with a vendor, with a marketing group, with potential employees, potential merger candidates, anybody who you're going to share business secrets with, it's a good idea to have a confidentiality and non-disclosure agreement. Sometimes they're called confidentiality agreements, sometimes NDAs, non-disclosure agreements, proprietary agreement, or information agreement, all generally referencing the same thing. I have a couple of clients. I've one in particular. He does a lot of very technical stuff, and I just reviewed one. He sent me one this morning. I review these things. It seems probably a couple per month for this client. We have our own that we send out, but a lot of times he's doing business with somebody else, and he'll send it to me. Here's the NDA that somebody sent. I generally take a pretty quick look at it. It doesn't take a long time. We're looking to make sure, one, we want to see if it's mutual. Two, we want to make sure that stuff is protected. We want to make sure that the party, if you're sharing information with somebody, that not only are they going to keep it confidential, but they're going to promise and make a contractual agreement that anybody they share it with has a need to know, and they're going to keep it protected. And then what are your potential remedies and where do you enforce it? Actually, a lot of elements to that. But these are some very common types of agreements that you'll see. You also see vendor agreements. You want to avoid signing any agreement in your own name if you could sign it just in a business name. In the unfortunate or unlikely circumstance that your business doesn't make it, you as the individual owner and practitioner are going to be unhooked for certain things, but you want to limit that as much as possible. You want to try and avoid signing personal guarantees. You want to avoid personally signing vendor agreements, any type of other contracts, unless you're forced into that situation. Anybody using healthcare is familiar with business associate agreements for HIPAA. Those will be required anytime you're potentially sharing confidential information. There's a general form for those that's accepted. So these aren't, a HIPAA BAA isn't something that should be heavily negotiated in my view. I have a general form. Some of this stuff is really the statutes and the regulations lay out exactly what's required. So it should be a pretty streamlined process. Leases for space and equipment, of course, are very common. Another note there, if you own the physical plant, the physical space where you're going to operate your practice, you want to own those under two separate entities, if at all possible. You don't want to have a medical practice, which is subject to potential claims, lawsuits, anytime you're providing professional services, you don't want to own that in the same entity where you own your business or your building, so that if you have a claim and you, for whatever reason, aren't successful on the claim, or if there's insurance coverage, but the claim potentially exceeds the insurance coverage, that now they're looking at not only going after the business and going after your personal assets, but also going after the building or some other big asset that the practice owns. So big pieces of equipment, valuable equipment, and real estate, you want to have a separate entity that owns that as a general rule, especially real estate. Equipment could be a little bit different. But real estate, you want to have a separate entity that owns that. And then you want to have a lease between the tenant, who's your practice, and the landlord, who's your entity that owns your building. I know you're probably signing for both of those. Have that lease. You want to pay rent. Yes, you're going to pay sales tax if you're in Florida on that rent. That's a minor amount of insurance that you're going to pay in order to keep a legal separation between the two in the event something bad happens. When I see an orthodontist or a surgeon or somebody that has these in one entity, it makes me cringe. And I actually had a case several years ago that I was involved in with a client who owned the real estate in the entity. It puts an incredibly high amount of pressure on the client and on the attorneys to make sure that we keep our eye on the ball and get some type of successful outcome, so we don't lose not only the business stuff, we don't lose the physical plan. Practice pointer here. And this really, all contracts, there are legal and regulatory compliance issues that permeate these contracts when you talk about the field of healthcare. So if you have any doubts, I mentioned leases, for instance. If you're going to be a group practice and you're going to have ancillary services, and these are going to be provided by equipment, you're going to do MRIs or X-rays or lab screenings or something else. You need to make sure that that everything you have fits together within the regulatory framework, so you don't get yourself in trouble for improper referrals, improper sharing of work, and so forth. All right, I said I had this provision a couple times, or this practice pointer a couple times throughout the slides. When you get a contract, the vendor sends you a contract. Leases, commercial leases, very common. Employment agreements, or independent contractor agreements. Do not assume that somebody who sends you a contract intends that contract is non-negotiable. Especially vendor agreements, I change those on a regular basis. As I mentioned earlier, confidentiality and non-disclosure agreements, I don't mark it up with a sea of red generally, meaning there's not a whole bunch of red line markups on the document, but sometimes there's a specific provision I went in there. I looked at one just recently for a client, and it's a contract with a national company, or an NDA with a national company, as they're exploring to do something together. And it had an enforcement provision for the state where that particular business entity was from. Well, I just added that it can be enforced there or here in Central Florida, because my client's in Central Florida. So I want to be able to, I didn't take out the other one. There's nothing that says you can't have a provision that says it can be enforced there or it can be enforced here. And if you're dealing with a party that has an objection to that, you really need to ask, is this, go back to my fences analogies, do I want to do business with somebody who really wants a one-sided relationship from the start? If you're doing business with someone somewhere else, there are certain things that you look for in contracts that should be equal. If we're both sharing information, it should be a mutual non-disclosure agreement. If we're both doing business together where there's some potential liability and we have indemnity clauses, as a general rule, I look for mutual indemnity clauses. If we're talking about enforcement, enforcement should be something that's equal for both sides. I shouldn't be at a significant disadvantage if I enter into a contractual relationship with you and need to enforce that agreement, and I have to go to your home turf, which is in another state or maybe in another country. Anything like that, to me, is going to be a big red flag that we're going to change that. Most of the time, counterparties will go along with it. And if there's a significant pushback, my response might be, why is there significant pushback on this issue? Is this really somebody that we want to do business with? That's really the first question. And then from there, we can usually work through it. Credentialing, This is common in healthcare, and this is essentially just making sure that the healthcare provider is qualified to provide the services that they are being licensed and authorized to provide and paid to provide. This will happen when joining hospital staff, when joining an insurance, a commercial insurance company, or any insurance roster of providers when you go in network with the insurance company. States can have their own licensing, credentialing requirements with accrediting agencies where you become you go through a similar process of accrediting and credentialing. The process is generally where you submit an application. There's a verification process, a committee review, and a decision, and then the re-credentialing happens every couple of years. If you're a practice and you join an insurance panel to become in network with an insurance company, and you add a new individual to your practice, a new provider, that new provider who's going to be providing services under the practice also needs to be credentialed with the insurance company. And don't assume because they were credentialed at their last employer that carries over. If you hire them into your practice, you need to update the insurance company and let them know that they're now employed by you or an independent contractor providing services under your NPI number, and make sure that they're brought under the umbrella of your business entity. Also be aware that a lot of the credentialing requirements contain additional self-reporting requirements, so that if you fill out the application and you make a representation, I haven't been in trouble, I haven't committed a crime, I haven't been sued, and then and something changes, you may have a duty to report certain things if they happen after the fact. So if you run into that unfortunate situation, you should probably be consulting with legal counsel on that issue. But one of the things you want to look for is to see if you have any self-reporting requirements, either with a credentialing agency or with a state board or something else, if you have something that potentially affects your licensing status. Practice pointer for credentialing is to start early. It can take several months to get this completed. I've had clients who get very frustrated because they bring somebody new in and it's taking a long time to get that professional credential. You also want to keep records. Once you go through this process once, keep a file. Now it's so easy with digital files. Keep a file on all this stuff. Have it all together in one place so that you have to go through the process with a different entity, or if you have to go through the re-credentialing, you already have everything together, and now you're just supplementing, adding the additional information to bring that information current. So once you have it all together, keep it all in one place as at least an electronic file, so it makes it easy to go through the process again and again. Patient documentation. This is something I get contacted a lot for as well. New practices starting up. There's certain documentation that is either required or highly recommended, and other ones that are optional. Some of the ones that are, patient registration form. This is capturing all the basic patient, demographic information, personal information about the patient. Maybe not required, but definitely a good idea for the practice to have. Some of it you are going to have is going to be required for their medical records. Notice of privacy practices required under the HIPAA privacy law. This is generally a required form. There is you don't have to get real creative with this form. There's a statutory form that I follow, and as a general rule, let me kind of take a veer off here for a moment on that issue. Sometimes the law will require you to use a certain form, or the statutes will recommend a certain form and say this information is required to be in the information that you provide to a patient. This is the case with the notice of privacy practices. It's also the case with Florida. There's a Florida No Surprises Act and a federal No Surprises Act. Certainly the Florida law has requirements. Patient Bill of Rights that's required. I don't think I have that form up here, but the patient bill of rights that's required. Oh, pardon me, I do have it at the bottom. Some of these forms, there's a statute that says you should have this information in there in this summary. I've been practicing long enough that in my experience, I follow the language from the statute exactly. I don't try to get creative at all. I'm not trying to create an opening for somebody else, another attorney or creative person, to make an argument that we didn't follow the statute because we changed the language. And it's amazing how many times over the course of my career, I have seen where there are statutory disclosure requirements, and then the language that is used is not the same in a form as the actual disclosure requirement language. Now, oftentimes, the statute will say that you have to have language in substantially the following form, where you have to include these points, and here's a suggested form. Look, you can have an attorney or pay somebody or do it yourself and be creative and say, well, that's suggested, so maybe because I just paid the attorney a bunch of money, they need to change some words. I don't do that. I follow the statute. And as long as you have everything, it's exact. Even sometimes there's language in a statute that doesn't make sense. You'll read it and say, that the language is a little nonsensical. Sometimes it's drafted by legislators. Maybe it didn't read it as carefully as they should, or don't have a legal background. Follow the language exactly, and then you never have to worry about the argument of whether you included the information and followed the statutory form. Uh, Other documents, the acknowledgement of receipt of the notice of privacy practices, informed consent. Informed consent is required or recommended for almost all procedures in Florida. There's a general, I see these in many different forms, but there's a general format to follow where you describe the procedure, potential benefits of the procedure, risks, alternatives, the right to refuse, right to ask questions, maybe who do you ask questions or had the right to ask questions, and you have the patient sign that form. Office policies and procedures, not required, but generally a good idea. So people have a good understanding. Everything from your business hours, when you're open, when you're closed, how do you cancel appointments? When are they going to have to pay for an appointment if they cancel? Financial policies are always a good idea. If you take insurance, how do you process the insurance? If you don't take insurance, but you cooperate with them getting insurance coverage, how is that done? Authorization to release medical information. Again, there's a form in Florida, at least Florida has a form for that at the Department of Health. I just follow the form. Has the information you want in the form, include that information. Telehealth consent. This has been a relatively new issue over the last few years. I have a specific form with information and I like to disclose with potential risks of telehealth. Has a lot to do with the with privacy and the technical aspects of telehealth and some of the limitations. If you're doing telehealth services, probably a good idea to have that form. And again, your state may have other forms. Nevada may have other ones. I'm licensed there. Florida has some state-specific forms, and wherever you practice, you want to, you can consult with. It's a good idea to have legal counsel, or if you're advising other people, if you're again a lawyer or an advisor that's on this webinar, make sure you understand from state to state what information is required and what forms are required. Whenever you are presenting these documents to a patient, you want to have them sign something acknowledging that they got them. One way to do this is have a form, an acknowledgement of receipt of notice of privacy practices that says I got the form and it's in the file. Another way to do it is to have them sign and initial things, provide the patient a full copy, and you have a full copy and keep a copy in the file with their initials on it. Have some mechanism to prove. It's one thing to give them the required forms. It's another thing to be able to prove that you gave them the form. The informed consent, obviously, if something happens and you're going to try to, you want to rely on the informed consent, you need to have proof that you not only provided them with the form, but that they signed it, they kept the copy, and that you got a copy of that form. Payments, payers, reimbursement. A few months ago, I think I did an entire webinar topic on payers and reimbursement. You can refer back to that webinar if this is something that has greater interest to you. Just want to cover some of the main issues as you're creating and advising new professionals on starting a healthcare practice. These are some of the big issues that you need to deal with. Obviously, establishing fees. That's usually outside the realm of legal. It's more of a consulting and a business analysis that happens, but I wanted to include it because it's important. What are you going to charge people? There's been a little bit of regulation and news on that, whether you have to post fees and so forth. So there is some regulation around it, but this is going to involve market research and trying to figure out what is the proper amount to charge for your services. Balanced billing is a hot button issue. There are restrictions against providing services for a patient and then trying to charge the patient for amounts that were not covered by insurance, whether it's government insurance or private insurance. Sometimes your insurance contract may contain a restriction that says you can't bill for amounts in excess of whatever the contracted rate was for the beneficiaries of the insurance company. There are limitations under the No Surprises Act that I mentioned earlier that are relatively new under state and federal law. Just be aware that if you're engaging in that, or if you intend to engage in balanced billing, you send the patient or you get the bill of patient a certain amount under whatever agreement you have with insurance or so forth, and you're going to try to collect the additional amount from the patient. I'm not talking about co-pays, deductibles, and so forth. You're trying to collect an additional amount above what the authorized payment rate was for insurance. Make sure you know what you're doing before you do that. Consult with the proper authority. If you're advising clients on that, make sure you consult with whatever the regulations, statutes are pertaining to balance billing. Look at the contract for the insurance company and see what the restrictions are. Another thing I want to focus on here is just different insurance carriers, your in-network and out-of-network status rates. Some of that is negotiable. Some of that is a little more limited depending on the type of practice that you're in. It's really on a case-by-case basis of what type of services you're going to provide and what rates can you get from the insurance company. I did another seminar a few months back on negotiating managed care contracts and really reading managed care contracts, figuring out what the terms are, some of the hot button issues in those contracts, particularly defined terms and how to navigate the defined terms of those contracts and what that means for your performance under the contract. The big one there is medical necessity or medically necessary. These are things that you want to be aware of when you're signing up for insurance and you're going in network with different providers. Read the contracts, even if you're not able to negotiate them. And some of them you can. Sometimes you can negotiate rates. There's certain provisions you may be able to push back on, depending on who the company is, what your bargaining power is. But even if you're not inclined to negotiate the contract heavily, or if there's not an opening to negotiate the contract heavily, make sure you at least understand what's in that agreement, so you make sure you're in compliance. Common way that we've seen over the last 5 to 10 years, a common dispute between providers and insurance companies. Insurance companies say that the provider is not billing in accordance with the contract and therefore won't pay. And then we get into an audit situation where clients aren't getting paid for services. This can go on for several months. Well, I'm dealing with a few clients right now, some where the insurance companies are trying to recoup money from past services that were provided, some where they've just withheld payments for the last 6 months and they're not providing payments because they say that the billing is not in accordance with the requirements of the contract. You want to understand what the contract says, make sure you're in compliance, and also understand what your dispute resolution mechanisms are, what's available to you in the event there's a dispute of the interpretation of the performance of that contract, particularly the payment provisions. Want to make a note here while we're talking about this issue before we move on waiving co-payments and deductibles. I'm asked sometimes what happens if you waive a co-payment, waive a deductible. You create a lot of problems. Often it's not permitted under an insurance contract. There is a state statute in Florida that prohibits the practice. It also potentially runs afoul of the anti-kickback statutes, both state and federal level. And the reason for that, or the justification for that, is that the co-payment or the deductible or whatever amount, the initial fee that the patient is asked to pay in order to receive the services, is sometimes a barrier to entry. It keeps them from overutilizing services. If a patient can just go to the medical clinic or to the emergency room or wherever every time they have a headache and they don't have to pay anything, the feeling is, or the rationale is the patient will overutilize services, and the providers are more than happy to provide these services because it's super easy. The patient doesn't have a big issue to deal with. I'm getting paid for it each time. And so if you just say, you know what, I don't need the co-payment, I'll just get the money from the insurance company. While that might sound nice in theory, it can create legal problems. if you have any questions about that, contact me. It's something I'm asked about, again, relatively frequently. Legal and regulatory considerations, another topic we could talk about at length. One of the favorite ones for practitioners, and I say that with a little degree of sarcasm, but for our legal advisors, these are the main, the laws I put up here on the screen on this slide are the main issues that we come in contact with when advising new healthcare businesses and ongoing businesses. These are the things we see on a regular basis. Kickback, I just mentioned that with respect to the waiving co-payments and deductibles. We see kickback statute issues that come up a lot. These could be marketing agreements. We'll talk about that in a few minutes. Referrals from other businesses. Getting referrals in exchange for any type of thing of value raises kickback concerns. It's not always unlawful or illegal or prohibited. It just needs to be evaluated for compliance. Patient brokering in Florida, other states have similar laws, similar to kickback. You can't pay somebody to send you business. You can't, if you're running a new healthcare practice, you can't set up and say, hey, any new patients that you send me, I'll send you, I'll give you a gift card or $100 or something else. If you're going to give out gifts for referrals, you need to heavily scrutinize that. It's generally, you can't do it. But if you're in a situation where you're paying a marketing company or paying somebody to help you generate business or advertising, there are specific restrictions for that as well. You need to make sure you're in compliance with that. Heavily regulated area, especially if you're dealing with federal kickback, which comes into play when you're taking insurance payments from any federal government payer, Medicare, Medicaid, TRICARE, so forth. Stark law. Similarly, if you are a patient, a physician-owned practice, and you are referring patients for ancillary services or what are known under Stark as the designated healthcare services, which is a list of 12 different services that if you refer patients to other services and you have any type of financial interest in the business, and it doesn't have to be direct, it could be direct or indirect, it could be referring a patient for an MRI and your spouse and brother are owners of the MRI clinic. There's a potential Stark issue there. False Claims Act comes into play anytime you submit insurance claims that you arguably shouldn't be paid for. And what I want to highlight in the False Claims Act is the qui tam provision. I'm not sure I know what qui tam means, but I know how it plays out. Qui tam is essentially the financial incentive that's provided for whistleblowers under False Claims Act. Obviously, you got to comply with medical privacy laws. You've got HIPAA, you've got state laws, medical record and reporting laws. And one that people don't think about that often, is biomedical waste. Depending on what you do in your practice, if you're handling any biomedical waste, in Florida, there's a certain volume and weight limit over which you have to have a special permit. So if that's something that you have to deal with, I just want to have this up here. So again, this is like a checklist. So you go through and make sure that these are the types of issues that you're covering in case that becomes an issue in your with the new practice. So with all these different regulations and laws and things you need to comply with, how do you make compliance practical? How do you do it without just constantly having telling your clients, okay, you need to hire me full-time to be your in-house legal counsel for your 2-physician practice? Or for the lawyers, where do you go if you have questions about some of these issues and you're advising clients and you're facing a new issue? Here's some resources that are up here. There's some really good resources on the government websites. HHS and CMS have resources for Medicare, Medicaid billing, auditing the audit process for billing. We rely on that quite often. Other issues, questions that you have under state law, ACA in Florida, the Agency for Healthcare Administration, has good resources for Healthcare Clinic Act for medical records, opening a practice, closing a practice. There are certain requirements if you're winding down a medical practice. Maybe we'll do that in another seminar. Things that you have to comply with respect to notice and publication of the notice, notifying patients, taking care of the records, letting patients know where they could get the records and so forth. Of course, other educational resources, publications, journals, and then legal and compliance consultants. And they each have a role. There's some folks that I've worked with when people are starting a new practice where maybe it's not, they don't need a lawyer for everything, but they need somebody to help them walk through some of these issues. And there are some consultants out there who can be very effective and maybe a little bit more efficient on a cost standpoint. Practice pointer here is, again, look to the resources, look to the help. Don't try to just wing this stuff. Don't go it alone. Healthcare is one of the most heavily regulated businesses, obviously, because you're dealing with people's personal health and welfare. I would say up there with financial and a few other probably more regulated than financial. So you encounter a lot if you're just the physician and you want to run a local practice, a little family, medical practice in your neighborhood, you're still dealing with a lot of these issues. It gets a little bit easier if you run your practice on a cash basis. I see more people going to that now. But I also see folks that are going to a concierge practice, but they still want to take insurance. Well, there's specific regulatory issues you need to deal with. You can't charge people a fee for concierge services. That's also something that's included within the insurance requirements, such as annual physicals and so forth. Don't be afraid to ask people for help, and don't overlook the fact that you're going to have to pay for some of these services. All right, compliance plans and officers. What I want you to be aware of here is that many compliance or many insurance companies and federal programs, sometimes federal state laws on particular practices or issues may require compliance plans be in place. For insurance, you may be required to have a compliance plan. You also would generally be required under that plan to have somebody who's in charge of it, who's going to be your compliance officer. I've listed some of the circumstances where you'll need the plan and why. And then on the next page, I'm listing some of the components of a compliance plan. This comes right out of CMS, so I didn't have to get very creative here. CMS gives you certain requirements for a compliance plan, and there's guidance and resources that are available. Practice pointer here. You don't need to overcomplicate this. You need to have a plan to deal with specific issues. You need to test it. Internal auditing is important, but I would rather you have a simple plan, or that you advise clients to have a simpler plan that they can follow than something that's more complex. It looks great on paper, and then if there's an issue that comes up later, you get a lawyer. And I've sat in these depositions, and I've taken these depositions. It's a lot of fun if you're the lawyer who's taking it, and then you ask the party being deposed to pull out their policies and procedures or their compliance manual, whatever, for a specific issue. And then you go down and you say, okay, what's this first requirement here? Did you do that here? What's the second requirement? Did you do that here? Why or why not? And you just drill down on that. And that can be very powerful. I don't want folks in this webinar to have clients or themselves be involved in that situation. Keep it simple, keep in compliance, and make it something that you can follow. All right, telemedicine. Got a couple minutes left, so I'll be able to hit a few more of these here. Again, I touched on this early. Telemedicine is a fast-moving area of practice right now. One thing I want to alert you to with telemedicine is more and more practitioners are engaging in a high telemedicine. Some are going to strictly, solely telemedicine practices, or telehealth, depending on the term you use. Generally, telehealth is considered to be broader than telemedicine, but they're almost interchangeable. What I want folks to be aware of here is that wherever the patient is where the practice is said to be. So if you have clients who are seeing patients, and the clients are in Florida and they're seeing patients in other states, unless there's an ongoing relationship and maybe there's an exception that applies, if they're seeing new patients in other states, generally my view on that is that they need to be licensed in that state. Again, there's some exceptions. There's also compacts and registrations that are available. For instance, in Florida, an out-of-state practitioner can register, and it's really not even, I wouldn't even call it an application process. It's a matter of just providing some information. You have to provide either insurance or the ability to financially support, financial wherewithal, and register in the state of Florida. And you can pull up that registration list of out-of-state practitioners who provide telehealth services here. But I have seen people get in trouble with it. So I want to make sure folks are aware that if you're providing telehealth, just because you're here, if the patient's somewhere else, especially if they're not coming to you, it's different, I believe, and there's a little more gray area. If you're seeing patients, if they come here to Florida to see you because you have a specific specialty like practice, and then they leave and you do a follow-up by telehealth, that's a different issue than having patients that you regularly see by telehealth that are somewhere else. You really need to consider being licensed there. Here's the statute in Florida, 456.47. I was involved in some litigation representing a couple of physicians a few years ago on the interpretation of that statute. Fascinating, because I think there's, no matter how well we try to draft law or the legislators try to do it, there are gray areas to be argued. And there was a specific provision in that telehealth statute with respect to what qualifies for services that you can provide as an initial appointment, what qualifies for what you need to do before you can write prescriptions in a telehealth appointment if you've not seen the patient personally. Really fascinating stuff. If anybody's facing those issues, you have questions about that, please let me know. Finally, I think this is our last topic here, is ancillary services. Oh no, web marketing. I'm going to have to wrap it up here because we're almost closing out. But this is it. I mentioned this earlier. If you're providing other services in your practice, make sure you take a look at Stark and you're in compliance with that. And look for, if you're providing these services, you really probably need to get legal counsel involved. And then finally, marketing and advertising. This is something I mentioned earlier. This is an interesting area, and what I want to point out for folks here is not only do you have healthcare regulation, but you've also got advertising, FTC. The FTC has really been coming down on endorsements, given the proliferation of social media and Twitter and people making endorsements online and false claims and so forth. So not only do you have to be in compliance from a medical standpoint, you have to be in compliance from an advertising standpoint, the type of representations you made. And it's cringeworthy, almost, some of the promises that some businesses are making. So you really need to take a broad view of that. And if you're in that situation, find somebody that's really familiar with these broad issues of advertising, marketing, business, and healthcare. I've done a whole seminar, and I'll probably do it again, on ethics when using social media with healthcare businesses. Something that I can do again. If you're interested, or if that's a question, please contact me and let me know. And I mentioned earlier, there are kickback concerns with marketing, so you want to make sure that whatever arrangement you enter into with a marketing group is in compliance. And again, the point I just made, you're covering a broad base of law when you're dealing with marketing and healthcare. Be aware of that and plan for it accordingly. And finally, in conclusion, I don't know if I'll have time to take any questions. I'm happy to stay on. We ran a little bit late here. And I appreciate you staying and hanging on. But having the right people to refer to, as I said in the beginning, I say this regularly, I'm not an accountant, I'm not a tax professional, I'm not a financial guy, I'm not an insurance guy, I don't do real estate. I've done webinars with folks who are specialists in real estate, specialists in accounting. Find the right people. And if you need any help, if I can help any of the advisors out there, lawyers or anyone else, feel free to reach out. If I can try to make a good referral, I'm happy to do that. And I appreciate you spending the time with me today. If there's any questions I can address before we hop off, I'm happy to do that.